Welcome. I'm Bertram de Souza, host of the Scribbler podcast and retired editorial page editor and Sunday columnist of the now closed Youngstown Vindicator, where I had worked for 40 years. Today, our focus is on the dark side of high school football. One of the most successful high school football programs in the state of Ohio is now in shambles. Youngstown's Ursuline High has canceled this year's season in the wake of two federal lawsuits filed against the institution and the Catholic Diocese of Youngstown. The suits allege that individuals in position of power and authority turn a blind eye to hazing, sexual assault, sexual harassment, and other illegal acts by players against another player and his sister and a female student. At the heart of the legal onslaught that has grabbed headlines locally, statewide, and even nationally is attorney Subodh Chandra of Cleveland, one of the top civil rights lawyers in the country. I first met Subodh 19 years ago when he ran for Attorney General. Since then, he has blazed a trail of significant civil rights lawsuits. It did not surprise me when I learned that Subodh had taken on this battle with Ursuline High School. I'm pleased that Attorney Chandra has agreed to spend time with me and my co-host, Cynthia Rickard, a veteran journalist who worked for 41 years at the Vindicator, to discuss the lawsuits and, more importantly, to talk about what drives him to pursue such civil rights actions. Well, Subodh, it's great to see you after such a long time. Thank you for agreeing to participate in this podcast. Before we start with the questions, Cindy and I'd like you to tell us something about yourself, and also about your career and how you got involved in civil rights issues.
Sure. Well, so I'm a civil rights lawyer now. I have been for almost 21 years. Before that, I had the opportunity to serve in public service as a federal prosecutor, as the law director for the city of Cleveland, as its chief prosecutor as well. I've had a varied career. I've worked in large firms, born and raised in Oklahoma, moved to Ohio originally to work for then Governor Dick Celeste between undergraduate and law school. And my wife, who I was dating at the time, we were trying to decide between California, where I lived 29 years ago, and here. And we decided Northeast Ohio is the best place to raise a family, and that's been borne out. So here I am, and I'd always been interested in civil rights issues. It's part of what drew me to the law, in addition to an interest in public service. And I had the opportunity as a civil rights lawyer to pursue public service through the private sector.
And there have been some very significant civil rights issues that you have taken on, and lawsuits that you have filed. So when I saw that you had become the lawyer for this on this Ursuline High School thing, I wasn't surprised.
I will say one thing, though, Bertram. I've seen that some of the critics of this litigation have described me on social media and to each other as an ambulance chaser, and I think they are, overestimating my speed. Because I'm far too portly to be able to chase an ambulance. But that's sort of an interesting thing that, people feel a need to try to attack counsel or disparage counsel whenever they feel the heat.
I know that well. When we were publishing, people who found fault with what I had written wouldn't talk about the issue or the subject or the content. They talk about my background. They talk about where I was from. They talk about my personal life, and it's sort of emboldened me even more. And I'm sure it does you.
That's right. As soon as they move to the ad hominem attacks, you've got them on the defensive.
All right, let's talk about it. Your federal lawsuits against Ursuline High School and the Diocese of Youngstown have been widely publicized locally, statewide, and even nationally. The suits are more than 200 pages long. Could you give us a synopsis of each of the lawsuits and sort of a non-legalese way of saying of doing this?
Sure. So simply put, let's talk about the first piece of litigation first, which is the hazing and sexual abuse lawsuit. That's the 200-page suit that was filed in federal court on September 2nd. And that suit alleges on behalf of a mother, her son, and her daughter that the son was subjected to extreme hazing and sexual abuse while he was on a 9-day football camp trip back in June of 2025. And that this was a part of the culture. The suit also alleges that the coaches were aware that this kind of activity was going on, didn't do anything about it, and that and in particular, there are some incidents that are vividly described of, just use of physical body parts to grind into the boy. It's gross. I'm not going to get into those details, but that's what's alleged. And it's further alleged that when the boy reported this to his mother, obviously he was shaken when he came back from the trip, that the mother raised this with the coach. And the suit alleges that the coach's response was, "It's just boys being boys," a statement that the mother understandably categorically rejected. The suit alleges, had a meeting with administrators who she perceived did not seem terribly interested in doing anything. She had to drag out of them a commitment that they would take action. To the best of her knowledge, no meaningful action whatsoever was taken, no meaningful independent investigation by the school, as it would be obligated to perform under Title IX of the Civil Rights Act, the Federal Civil Rights Act. And so the complaint is essentially alleging not only violation of Title IX, because the school, we believe, receives federal funding, but also Ohio has a statute that provides for civil liability for any criminal act. And under that statute, there are allegations of, sexual assault, of battery, hazing, which is also a criminal violation and also has a civil cause of action. So there's a lot of claims in there. There's a lot of allegations in there. And so now we move forward with the court process to try to resolve that. I can turn now, if you want, to the
Right.
second suit.
So first of all, before you turn to the second one, when did these acts occur? What?
The acts are alleged to have occurred in June of 2025 on a 9-day camp trip through 3 states. And then upon
What exactly does
return,
that mean, a camp trip? What kind of camp trip does a football team take?
well, that's a great question. Having not been a football player, I guess I don't understand it myself. I mean, we mere soccer players never got such opportunities. I really don't know, but apparently they were going to 3 different states and they were doing activities in those states, perhaps some sort of practices. But they were on a bus and they were going from state to state. The suit alleges that it was through Tennessee, Florida, and Alabama. We recently learned that Alabama may be incorrect, that one of the incidents may have taken place in Georgia. So we're finishing our investigation on that, and we'll amend the suit if it turns out we were mistaken about something happening in Alabama, if it actually happened in Georgia. I suspect we're going to find similar laws protecting children there. So that's the gist of that suit.
Okay, and then when were you contacted by the mother? How long after the alleged misbehavior, alleged acts?
I'm sorry, I'm not sure of the exact time frame. It does take us a few weeks to investigate and draft a complaint and get something together and be sure that we've reviewed all the documents and all the messages and verified our facts. So I know that we had been working on it for at least a few weeks before we filed. I know that probably would have been at least sometime in August and perhaps as early as July.
So the mother contacted you.
Yeah.
Is that how
Yeah.
it occurred?
Yes.
Because you have said there is a local law firm that you're
I
working.
think the mother was originally in contact with our co-counsel, our local
Oh,
Youngstown
okay. All
counsel.
right. Okay, so let's do the second one then, the second suit
Yeah.
that you filed.
So the second suit concerns, I think this is important for your listeners to understand. I mean, first of all, we have consistently been calling under these circumstances after we filed the suit on September 2nd, the hazing and sexual abuse lawsuit allegations. We have been calling on additional victims or witnesses to come forward if they have additional information about these allegations or if they themselves had any negative experiences that they allege they had at Ursuline, including involving the football team. And we have heard from many people with information or who say they have information. And that's how it resulted in us a mere 8 days later filing the second suit. And we anticipate there are more coming. Also alleged in that suit is that the boy who alleges he was improperly hazed and sexually assaulted, also alleged there is that his sister faced retaliation and intimidation by at least one of the players and his friends. And that's detailed there where, there was alleged stalking, alleged menacing, showing up at her place of work, showing up at a football game where the boy was playing and the mother was, for a football game that this player allegedly had no reason to be there. I mean, just no reason to be there. And then the mother actually confronted him and said, do I need to call the police or are you going to leave? And he said, I'll leave. I mean, didn't even argue that he had every right to be there. So now jumping forward to the second lawsuit, we filed that, I think, around September 10th. So in that 8-day intervening period, we heard from, as I said, several people, but including this family. And this suit now alleges that there was a daughter who was a minor and actually very small. She was just starting her freshman year over the summer before freshman year, was taking a gym class. And one of the football players who is named in the other suit was coming on to her sexually, to put it mildly. I mean, was directly propositioning her for sex. She rejected his overtures. He was over 6 feet. She's under 5 feet tall at the time and very small and was, let's say, underdeveloped. Okay. So this was a shock to her coming out of Catholic grade school. And so she rejected his overtures, had no interest in it. The suit alleges that he persisted and persisted. It got more aggressive about it. And then at some point, the suit alleges he actually picked her up and slammed her to the ground. And then, hurt her back, dragged her on her back against rough turf. She got severe turf burns. And what the suit is alleging is that, again, when mother and daughter went to the administrators, in particular Assistant Principal Demore, and tried to raise concerns about this, that they did not get a warm, favorable reaction about this. There was a promise that the mother did extract eventually, the suit alleges, that the children would be separated going into the fall. And that did not happen, the suit alleges. And that instead, the girl, over the course of the next couple of years, was again persistently receiving this aggression and sexual harassment. And
it continued for 2 more years.
Yeah, so the allegation is it was basically a 2-year time frame. So eventually she left the school freshman year and sophomore year. And that again, she got put in a class with him sophomore year. And the suit is alleging that at some point the daughter actually says to Assistant Principal Demore, "You're not going to help me, are you?" And Demore allegedly said no, just a simple no. So what it's alleging is a deliberate indifference to her rights under Title IX, which protects against sex discrimination and sexual harassment in schools, but then also, again, a variety of criminal statutes. So including, by the way, the failure to report. Remember that there's a criminal statute in Ohio that requires teachers, administrators, coaches to report child abuse. And what the suit is alleging is that that did not happen, again, under that civil liability for criminal acts statute.
What was this young man an athlete that was
Yes.
harassing her?
Young
And
man was a football player who's also a named defendant in the other hazing lawsuit.
I assume he was not a freshman at the time.
No, he too was a freshman at the
He
time.
was.
Yes.
And was she an athlete? I don't understand where this dragging across turf occurred.
There was a gym class, there was an event. This girl was not at the event. It was like a water balloon type of event, something, and she was elsewhere with some friends, and that's where this is alleged to have occurred.
In investigating these alleged crimes, you and your team have done an exhaustive work digging not only into these allegations, but also into the history of Ursuline. What have you found as far as Ursuline goes and the culture at this very prominent Catholic school? And by the way, I am a product of Catholic education. So what have you found?
Well, what I'll confine myself to is not every piece of evidence we uncovered, but what the allegations of the suit are, what the suit alleges. And we're talking now about the first lawsuit, the 200-page complaint about hazing and sexual abuse. It alleges, first of all, that there was a culture of hazing in the football program going back years, that the coaches were aware of it, that the coaches tolerated it. Some of what is alleged is some of this stuff was taking place right in front of them and they didn't care, to act. By the way, I think it's also fair to say that there's a parallel federal, state, and local criminal investigation going on these matters. And we've received no information that anything we've alleged is incorrect other than that issue about what state something may have occurred in. What the suit is alleging is there's a legal theory or a legal cause of action in Ohio, a claim for negligent or even reckless hiring, retention, supervision, training against business entities like a school. And what the suit is alleging is that the school itself, Ursuline, negligently hired and retained, supervised, and trained two of the three individual coaches allegedly involved in this, based on the fact that it's alleged in the suit that they had dubious backgrounds, they had, poor records of coaching. Some of this was open and notorious and available. And so that's what the suit is alleging. And anybody interested can visit our website at chandralaw.com and read the complaint in its entirety. And those details are set forth there. And there are links to news articles about at least one of the coaches where, it was understood in the public that this was a coach who had a problem. Now, it's further alleged.
Before you go there, could you name the coaches, because there's so many other people involved? I just don't want to.
So the two coaches who are alleged by the lawsuit to have had problematic backgrounds are Coach Reardon, the head coach, and McGlynn. And that's what I was getting to, is that as to head coach Reardon, what the suit is alleging is that he had a previous problem, not only in another job, but at Ursuline that was known, and that a senior diocesan official, because the diocese has to sign off on all this hiring. Apparently, the hiring happens by contract signed by the bishop. That's my understanding. And so a senior diocesan official, the suit alleges, opposed the hiring of Reardon because of his background and his prior problems allegedly at Ursuline. And the president of the school, Father Murphy, is alleged to have insisted that Reardon be hired, and the prior bishop, who has since passed, allegedly approved that, overruled the diocesan official who was recommending against Reardon's hiring. So that is also set forth as a set of allegations in the complaint, and that is one of the reasons that the diocese is named as a co-defendant along with Ursuline High School, based on this negligent and reckless hiring, retention, supervision, and training theory.
There's been exhaustive press coverage on this. And So much so that, Ursuline's football season has ended. Um, there have been lots of comments and statements issued by various individuals, including officials at the school and Bishop Bonner. I'm sure you've read the statements from both school officials and Bishop Bonner. And when I read those, it struck me as they seem to suggest that it's wrong to accuse them of foot dragging or downplaying the seriousness of the allegations. How do you respond to that?
Well, all I can do is refer you back to the complaint and the details that are alleged by our respective clients in the two matters, and they report deliberate indifference by the school and the school officials. They report, and the suit alleges, for example, the comment by a coach that it's just boys being boys. That is, from our client's perspective, and as the suit alleges, completely unacceptable reaction to the level of abuse being alleged. So this is all going to play out in the court process. There will be the next steps if the litigation process unfolds as it usually does. It will be a process of discovery, and information will be exchanged and documents will be exchanged. But you can see in the first suit, the hazing and abuse lawsuit, we have included some of the text message communications with the administrators, with the coaches, and they do not in the suit present a pretty picture of people who are interested in trying to address these issues. Indeed, the suit alleges that when these issues were first brought to the coach's attention, that McGlynn and Reardon, it's not like they acted shocked or surprised that any of these things were happening. Instead, the first reaction is it's just boys being boys. So, I mean, that's all I can really say at this point. We are certainly we have some cautious optimism about our prospects based on the information that we have. I mean, here's a very simple response to the kind of we did everything we were supposed to. Then why did they wait until a suit was filed and there was publicity before they put two coaches on administrative leave, quote unquote, pending investigation? If the investigation's done, what further investigation do you need to do? And why do they wait until then to supposedly reach an agreement with Reardon for him to be indefinitely suspended? Why is that happening after a suit is filed only? I mean, if they had done everything they were supposed to, if they had held everyone accountable they were supposed to, the football players, the coaches, then why is this happening only after the suit is filed? So the problem with the statements made by the diocese, the bishop, the school, is every time they open their mouths, they just give us more material, and they give us more. It becomes a target-rich environment for us to disprove their statements. And we have more information, I think, than they realize we have about who did what and who didn't do what and what they did with these players. And I expect that law enforcement also has that kind of information. And one thing again, I'm speaking for myself, I'm not speaking for law enforcement. I'm telling you my perception as a former federal prosecutor, and I'm just putting my hat on now, not as a civil litigator in the civil rights matter, but as an advocate for the alleged victims in the criminal justice process, which is a different role. My perception from my client's cooperation with law enforcement is that law enforcement is taking this very seriously, and that the scope of review goes beyond just the players and their conduct, but goes right to the heart of the conduct of coaches, the conduct of administrators, that obligation to report child abuse, and all of the obligations under criminal law. Now, how that is eventually going to shake out, whether there will be charges, of course, I can't speak for law enforcement, but I am confident that law enforcement is taking this very seriously. And anybody who knows my reputation knows that I will be the first person to criticize law enforcement if I don't think they are doing their jobs. And if, as I did in the Tamir Rice case, for example, the 12-year-old boy who was shot by Cleveland police, I was very vocal in saying that I didn't think law enforcement, I didn't think the prosecutor's office was fairly representing the interests of the victim family in that, and I was able to articulate why.
And you
here,
won that suit, by the way, right?
yeah, and here I am very, uh, I'm, I am impressed about the level of seriousness with which law enforcement is taking this matter, as well they should, given the seriousness of the allegations at issue. And I think they have a lot more information than we do, by the way,
Cindy,
because they get to talk to a lot more people than we do.
okay, and Cindy, just one quick, you've had extensive experience with civil rights issues and civil rights lawsuits. How does this one rank in your estimation and in your experience?
Well, it's sort of like asking me to choose from among my children, right? But I will say, which I could never do, but I will say this ranks up there in terms of its level of seriousness. We have been involved in investigating and filing suits over civil rights violations, very serious ones, including wrongful deaths, police shootings. We've been involved in major sexual harassment lawsuits, including many that are pending right now that we view as incredibly serious. But in terms of the scope and scale and sweep of what is alleged here, particularly in the first suit, the number of people who are alleged to have known, the number of people who are alleged to have not done the right thing and to have fulfilled their obligations, the seniority of those people, it's pretty sweeping here. So this is up there. I'd say this is certainly in the top 10 in terms of level of seriousness in the scope and scale of what's being alleged.
Subodh, you were talking about law enforcement being involved. Is that only Ohio law enforcement, or did some of these acts occur in the other states that they were traveling in? And would their law enforcement also be involved?
Our clients have been fully cooperating with the FBI, with Ohio BCI, the Bureau of Criminal Investigation, and with the Youngstown Police Department.
Okay.
We have every reason to believe from our discussions with them that they are in communication with law enforcement agencies in other states. We have not been a part of those discussions as yet.
Okay. I have a lot of Catholic friends who are very curious about this trip, and I've heard that this was more of a college tour, which would explain why they were in several states. And I understand it wasn't the entire football team that went on this. Is that correct? On the trip?
I believe that that is correct because there's only a certain number of players. It's a significant number of players, but there's only a certain number of players who are alleged to have been involved in this. I don't believe that every player on the team went, but I offhand don't have that information at hand.
Do you know if they were all invited? Was it only for seniors or juniors and seniors?
I do not know. I know that my client in the first suit was very, very young.
Hmm. And also, do you have any idea who paid for the trip or where permission was granted? Was it the alumni, the booster club, parents, the students themselves?
That's outside of the four corners of our suit, and so I'm not really able to respond to you at this time, and I don't have that information.
Okay. The primary question I wanted to ask was, this week, parents of students who are not involved in the hazing appealed to the community, as
Sure.
you saw, to recognize that the discipline that's being levied on the entire football team and thus the school and the reputation of their students and their teaching. And also, I imagine the cheerleaders, the band, they're all out for the season as well. And they're complaining that their kids are being damaged by this, to the extent that it's damaging their futures. It's putting scholarships at risk. I imagine it's putting at risk them getting noticed at football games by the college sports guys that come and take a look at these young kids playing. What do you have to say to them? Do they have any way to help their kids that haven't been involved in this, weren't involved in this, but are basically being punished as a result of this?
The objective of both of these lawsuits the hazing and sexual abuse lawsuit, and then the sexual harassment and physical violence lawsuit. The objective of our clients in both suits is spelled out in the complaint, and that is accountability across the board. Accountability means accountability for administrators, accountability for coaches, and accountabilities for football players who were involved. Involved means engaged in active hazing, holding other people down, making recordings that amount to child porn, as alleged in the suit, disseminating that, saving it, sharing it, not only within the football program, but out into the community. And there were a lot of people involved, according to the allegations of the suit. So I think what my client's response to parents who are concerned that they and their kids are effectively wind up being collateral damage in this situation would be that they need to turn to the diocese and Ursuline High School and the administrators and the coaches and fellow players and seek accountability themselves, not to blame victims, because that makes no sense. Is the response that victims of hazing and alleged sexual abuse and all the, dissemination of alleged child porn and all of the things alleged in this suit, does that mean those individuals should just keep their mouths shut, seek no accountability, and that a culture like this should be permitted to continue and not be exposed, especially if administrators are alleged to have acted irresponsibly?
Well,
Of course not. There's not a parent that would say that if it happened to their child, that they should just keep their mouths shut. So what I would say respectfully to parents that are concerned is that they too should be demanding answers and accountability. And they know, many of those speaking out know, and we're paying close attention to who's saying what, and there are many, many defamatory comments being made about our clients, and we're paying very close attention, mind you, and we are ready to seek accountability from those individuals as well. What I can say to those folks is simply this: you need to be very careful about what you're alleging about our clients, because we know that many parents and many of the players who are alleged to somehow be innocent victims of all of this were involved, saw the videos, have the videos, disseminated the videos. We know that. And many of these parents have seen that as well. So, and there's one assistant coach in particular, by the way, who's been going on social media and says, from what he was told, certain things didn't happen. Well, who told him?
Right.
Where is that central message coming from? Is it coming from fellow coaches? Is it coming from administrators? Because that individual knows that this occurred. That individual knows it occurred. And we have that information.
Just one question. So I didn't get the impression from the little of that group that I saw on, public broadcasting, that they were blaming the victims. But
some have been. And I want to be clear about this, because that little press conference that was led by an assistant coach who, as far as we are concerned, is acting for Ursuline and is advocating for Ursuline, is acting as an agent of Ursuline. That person is an assistant coach, and that person is trying to rile people up and disseminate falsehoods and get all of these other parents to believe a narrative that coach knows is not correct. And I think I'm going to leave it there, because I will tell you that our next amended complaint is going to address these issues. It's a next step in the litigation. Our next amended supplemental complaint will likely address these issues and lay out, and they've invited it. He's invited it with his conduct.
Have any of them
and it may have to lay out some details that may be uncomfortable.
Yeah. Have any of them contacted you to maybe join the suit?
Yeah, so as I said, we have heard from a number of additional victims or people who allege that they were victims, and we're investigating those things between September 2nd and September 10th. We learned enough about one alleged instance to be confident enough to develop and file a new complaint. We are working on some others right now. Some of these issues may get addressed through new civil complaints, which we anticipate. Others may be addressed through the underlying litigation through an amendment or supplementation, or it could be both.
Subodh, in your lawsuits, you do not name the accused players, and nor do you name the victims, but you do list the parents and even have their home addresses. And I went through and saw where they were from and all of that. Could you explain the legal basis for this, legally, what's going on here?
So
And
look,
also to what extent are parents responsible for the behavior of their children?
well, it's that second question that answers the first
Okay.
question. And again, I don't want to get into our strategy and
Yeah,
deliberation,
I
but
understand.
we reached a conclusion that to hold the parents accountable under a particular statute in Ohio that holds parents responsible for some of the acts of their children, that we may have needed to plead with some specificity as to their names, to the extent we know them. And we're still trying to learn all of that information as to all individuals. But there is a statute in Ohio that allows one to sue parents in some circumstances for the violent acts of their children. And that is the statute under which those individuals are named.
Does that stop at 18, that the parents would be responsible?
I don't know the answer offhand, but I believe so. I mean, I believe it would stop at the age of majority, but I don't have that
So
right.
I don't know if there are any of these players that are have already reached 18, but if they have, would they be added to your complaint?
If the way that we have approached these things is, this is a very sensitive subject. The offenders who were minors at the time of the alleged offense, we are going to treat in the civil litigation as minors with the same respect that would be afforded them, say, in a juvenile court criminal process. The law permits that. We are about to file a motion with the court, if we haven't already, asking for permission to proceed under these pseudonyms, not only for our clients, but also for the minor players. And we are trying to be as protective of their rights as we can be.
Reading the lawsuits and the allegations that have been made, and then the comments from the school officials as well as the Catholic diocese, as a Catholic, obviously, I'm as disturbed as I have been over the pedophile scandal, the priests, abuse of children by priests, and then the protection of priests by bishops and archbishops, and even reassigning priests to other dioceses or Arab parishes where they continue the abuse. I don't want to say that this is a Catholic culture, because obviously I'm a,
And we're not alleging that.
no, not at all. And I know you're not. But when reading your lawsuits, I get the impression that you really are passionate about what you're alleging, and about protecting young people against the kind of abuse that is being alleged. In that regard, should heads roll? And where should that begin? Because you've got two entities. You've got the school, where you have a president, Father Murphy, and you've got the board. And then you've got the Catholic diocese, where you have the bishop and you have the superintendent of education. And, it almost seems like the bishop, in one of his comments, said something like, I expect that the board of Ursuline High School will do the right thing. And to me, almost seems like, I got
Watch hands up.
yes, passing the buck. So how far, what should be the outcome of this?
Well, so again, I just echo the allegations of the complaint. The complaint alleges that the poor decision-making at least with respect to some of this, the original sin, if you will, was the decision by the prior bishop to permit the hiring of at least one coach over the objection of a diocesan official who red flagged it. That original sin is recounted in the allegations of the complaint, and the complaint is alleging that if not for that, then these things wouldn't have happened, because there would have been responsible leaders in the school who wouldn't have permitted a culture of hazing and sexual abuse to occur. That's what the complaint is alleging. So that starts at the top with the prior bishop. Then there are allegations about the role of the coaches. There are allegations of the role of the administrators and alleged deliberate indifference to what was occurring, cover up of what was occurring, all the way through the present moment where you suddenly see two people being placed on leave and one indefinitely suspended when they'd been claiming they did everything they were supposed to do all along. So I think the complaint is pretty clear that the families in both of these suits are seeking accountability for as far up the chain as the decision-making goes. And that's something we will ultimately find out in discovery.
And there has been a question raised about the relationship between the school itself, the school board, the president of the school board, and the Catholic diocese.
Yeah.
I
want to address that.
Please.
Because it goes back to your comment. Frankly, I was shocked by the bishop's statement that somehow it's up to the school. The buck stops with the bishop. The buck stops with the Vatican. Okay, that's where the buck stops. It is our understanding, and the complaint alleges, that the bishop signs the contracts for all of these administrators and coaches and officials. So the buck stops at least with the bishop. And to say, oh, I'm sure they'll make great decisions, to me, especially when the role of the diocese itself is alleged in the complaint, is not an appropriate position to take. But ultimately, the diocese and Ursuline officials are going to have to decide how they want to handle this. And who knows what the truth is, whether the bishop is weighing in behind the scenes, we don't know. But to our clients, that statement was incredibly troubling, because again, it suggested a level of passing the buck and just somehow washing one's hands of a situation that is alleging some very serious, the suit is alleging some very serious things. And then while at the same time professing sympathy for victims, our clients just aren't buying it. They just aren't buying it, right? I mean, that's their reaction to it. They're like, you can't express sympathy for alleged victims while at the same time saying, I have nothing to do with this, and walking away.
Do you know,
that's their feeling about it.
have any of the students been disciplined in any way besides the entire football season being canceled?
It's so the issue of I'm going to start with the last part of that. The issue of the football season being canceled was never an objective of the litigation. It's not something that our clients were seeking. If that's ultimately a decision that Ursuline has to make based on allegations coming to public light, then that's what it is. But that was not their objective. Their objective was accountability across the board, and that includes accountability for a very significant number of players alleged to have played a role in one way or the other as defendants in the lawsuit. Now, if so many people are involved, and if this is part of the culture of the football program as allegedly tolerated by coaches, well, then in those circumstances, if there's proper accountability, there would be accountability across the board for all of those football players. So now, to the first part of your question, it is our understanding that there was no meaningful accountability for the players who were involved here. We have reasons to believe that. That will all come out here in the days that come. But we have every reason to believe that. If there were suspensions, they were very temporary, okay, for the purpose of just trying to sort a couple of things out. But then those were done. That's our understanding, and the complaint is alleging all of that. So we will see, right? There's a lot of claims we did everything we were supposed to do, but we know that that is belied by the fact that they then placed two people on leave and one suspended after a suit is filed. So if they really had done everything they were supposed to do, wouldn't have that have happened before? Of course it would have. So that's exhibit A on why we know that they didn't do what they were supposed to do.
Ursuline officials have said, and I'm sure you're aware of that, that disciplinary action was taken against some of the students involved, but others had left the football program or the school before proper disciplinary action could be taking place. Is that an accurate description of what?
It may be true that a couple of players had left, but as to players who were allegedly disciplined, it is our understanding based on the information we have developed as alleged in the complaint that there was no meaningful discipline against players who were involved, especially those who had a central role. We have plenty of reasons to believe that. As we amend and supplement the complaint, we may wind up providing further detail on that. We're still developing information. This is a fast-moving investigation. Law enforcement has its own investigation going on of these circumstances, and our clients are cooperating. And it's very clear to me from the cooperation and interactions with law enforcement that we're having that they even have a lot more information than we do. And so, look, the bottom line is there are a lot of players that are named as defendants in this suit, and many of them would be wise to come forward and cooperate in this matter. And we invite them to, either individually or if they're represented by counsel, their families. We would want them to engage with us and talk to us and help us understand what happened here and who was involved. We understand, no matter how serious the allegations are, we understand that they were minors at the time.
Right.
May have been physically mature minors, but they were minors at the time. And so ultimately, what our clients are hoping to do is create an accountability culture in this situation.
You've used the phrase meaningful discipline. In your past experience as a civil rights lawyer, could you define what meaningful discipline would have meant in a case like this?
Well, I think you look at the individual conduct alleged by player in the complaint, and you say to yourself, what would be the appropriate remedy in those circumstances? Would it be a finger wag, or would it be some sort of a serious consequence? Maybe a serious suspension, maybe an expulsion, maybe being sidelined from playing, something. But when you're talking about coaches and what's alleged in the complaint about the coach's role and the administrator's role, there's zero accountability for the administrators. It appears that the school and the diocese are standing behind at least the administrators. And we'll see how wise of a choice that is. If you look from September 2nd to September 10th, between September 2nd and September 10th, we developed additional allegations that Assistant Principal DeMoore was involved in another alleged cover-up and neglect and deliberate indifference to someone's pain and suffering. So again, we'll see how all this plays out, and I think the public will be able to understand all of this as the suit unfolds.
Were you surprised by what your client, the young female, had said about the assistant principal DeMoore when this young female goes to a female assistant principal and says, "Help me"?
Those allegations in the complaint are very serious in my estimation. Yes, that's a very serious matter. When you go, after 2 years of begging and you finally beseech the assistant principal, allegedly, you're not going to help me, are you? And the answer is just a firm no, a simple no.
That's pretty shocking.
That's an extremely serious allegation.
Yeah, that's pretty
And
shocking.
and so ultimately, the school, as the suit plays out, is going to have to explain, what did it actually do? Did it actually do anything? Was there any meaningful consequence for the player involved? What did it do? Why was this girl in the same class with this boy who was her alleged harasser? What's the answer to that question? That's the kind of fundamental question that this suit is raising. And then why would Ursuline and the diocese continue to back such a person? These are fundamental questions raised by this suit. So we will see. The process will have to play out. And ultimately, perhaps there's a reasonable explanation for all of this that our clients just don't know about.
Mm-hmm.
We'll see.
But ultimately, what are your clients seeking? In a situation, especially in a case like this, talking about monetary damages almost seems obscene. But that's always a part of lawsuits. There's always discussions about settlements. There's discussions about, is there middle ground? Can we work something out? So what exactly are your clients seeking here?
So in recent years, because so many of our suits that we handle or litigation that we handle or even advocacy for crime victims that we handle, there's been a kind of an overlap between my background as a federal prosecutor and advocate as a prosecutor and my background as a civil rights advocate in civil litigation. So I've given a lot of thought to this question. And whenever we talk to our clients, we really try to ask that very question. What do you want out of all this? We talk to them about what's feasible, what's achievable, what's possible, but also we want to hear from them in their own words, what's achievable. What is abundantly clear from the allegations in these two lawsuits is that both sets of clients, both families, want to see accountability up and down for everyone who is responsible, from the diocesan level to the administrator level at Ursuline, to the coaches level, to the player level. That's what they want to see. Now, civil litigation and criminal litigation have their parallel systems, but they are different.
Right.
So for example, and I hope I'm not getting too encyclopedic here, but I think it'll be interesting to your listeners to think about how we think about this, right? So in a criminal prosecution for a crime victim, there's only a couple of things that can be achieved. One is getting the satisfaction of seeing just desserts or just rewards to the alleged perpetrator in the form of incarceration or probation or a fine, a criminal fine, which gets paid to the state, by the way,
Right.
not to the individuals. And there's also criminal restitution. But what a lot of people don't understand is that under Ohio law, and I think the law of most states, criminal restitution is limited to hard economic out-of-pocket expenses. So, for example, if there were days missed off of work, you might be able to persuade a judge to say, all right, I'm going to give you your 6 hours that you left for work when you were at a hospital, or you had some out-of-pocket expenses for hospital bills or for psychiatric or psychological expenses. I'm going to award you that. And not every judge does, okay?
Mm-hmm.
But what you cannot get out of the criminal litigation process when you are a victim of a civil wrong or even a criminal act that can be turned into a civil wrong, under Ohio law, you cannot get compensation for any severe or even mild emotional distress that you have experienced as a result of it. And let's think about this. Rape victims, sexual assault survivors, sexual harassment survivors, often that intense psychological distress that can be debilitating, that can last a lifetime. In the case of a child who's alleging that he was, that pornographic images were taken of him and disseminated, that's going to chase him the rest of his life. That's going to haunt him the rest of his life, if that's true. So you can't get anything out of the criminal justice process that you can get from the civil justice process in terms of that emotional distress, in terms of punitive damages that might punish or deter somebody like an Ursuline High School from conducting itself in the future, or administrators from conducting themselves in a similar manner in the future. You can't get those things out of the criminal justice process. So we are looking at this holistically. The complaint is pleading these things holistically. Our clients, while cooperating with federal, state, and local law enforcement, because they do want to see criminal justice accountability for those involved, are at the same time pursuing their civil remedies. And I would say to the people who are cynical about that, well, what if it were your own family member who were alleged to have experience this sort of thing, right? I mean, you would be the first to say, of course, my family members should be compensated for severe distress that they've experienced or may experience into the future. So that's really what our clients are looking for, is every available remedy, because for them, this is about accountability across the board. It's not about being bloodthirsty. It's not about trying to hurt people. It's certainly not about trying to hurt cheerleaders and band members and people who had nothing to do with this. Of course not. But it is about accountability. And ultimately, those people who have been harmed by alleged misconduct by Ursuline officials or football players need to focus their ire on those individuals and not on alleged victims who are trying to bring to public attention what they experienced and seek accountability for those things through the criminal and civil justice processes.
In looking into investigating these allegations, talking to parents and the victims and all of that, what advice would you give to young people who are targets of hazing, who are targets of bullying, who are because this has become so commonplace, because of the internet, because of online stuff. How should children and parents deal with this?
So, of course, unfortunately, not every misfortune along those lines has a legal remedy. Okay. So first and foremost, young people who experience these sorts of things have to speak up. They have to speak up to a trusted adult. Part of what is alleged in the suit is that part of the harm to our young clients in both suits is a sense of betrayal, is a sense that they went to the adults that they expected to handle things. They did all the right things, and they expected those adults to act like adults, and the suit alleges that they didn't. They didn't act the way that they were supposed to. And that results in a great sense of betrayal to young people who lose their innocence from that experience. So, what I would say to young people is, nevertheless, you have to try. You have to speak up. If you've experienced something, you have to say something. You have to say something to a trusted adult, whether it's a parent, a guardian, a grandparent, and whether it's a teacher, whether it's a coach, whether it's an administrator, somebody over their head. You have to try. You have to find your voice, and you have to try. And most of the time, in my humble experience, those adults will want to do the right thing. They're going to want to stand up for you, and they're going to want to protect you most of the time. Sometimes they won't. And that's what's alleged here. Sometimes they won't. And then you have to explore what your alternative remedies are, have an adult work with, an attorney to see if there might be some way that it can be addressed, either as an advocate through the criminal justice process or through the civil justice process, or both, or by reporting the allegations to state licensing officials who might be able to investigate. And it's my understanding they take these things very seriously, to athletic associations that may take this more seriously. So there are remedies, and you have to sit down and try to figure out what they are. But above all, just don't stay silent. Don't just take it. When it happens to you, when the bullying happens to you, when the hazing happens to you, it's wrong. It's wrong. And part of what we have to tell our young people is, because if they wind up in a culture like this, they start to feel gaslit. They start to feel that somehow this is normal, and that they're supposed to just take it. The suit is alleging that the boy who's alleging the hazing and sexual abuse, he didn't know what to do. He was ashamed. He didn't speak up for himself. He didn't know what to do. Then finally, he told his mother. He broke down and told his mother, according to the allegations of the lawsuit, at the end of the trip. And so this is something I think that young people have to understand. Hazing is defined as criminal in Ohio. It's a fairly narrow definition. It has to be extreme, just a little bit of teasing of somebody or playing a little harmless prank. I mean, that's not criminal hazing under Ohio law. But the sorts of things alleged here would be criminal hazing, and there'd also be civil liability for those things under the hazing statute. So, we have to give our kids some space to know that they can trust us and come forward and that we will try to stand up for them. There's a sense of shame and guilt that occurs. And then, as we've seen after the suit was filed, there can be an immense social backlash and personal attacks and accusations against the mother about her motives. And I mean, horrible things are being said about these families, horrible things. And ultimately, it's hard to take those things when you live in as intimate a community as the Youngstown and Mahoning Valley area. It is a really hard thing to have people saying these nasty things about you. All I can say is, as to the second lawsuit, what mother winds up selling the family home of 28 years to move her kid into another school unless she thinks something very serious happened to her child after getting into a school with the positive reputation of Ursuline?
Mm-hmm.
So it has to take a lot for a mom to do that, but that's what occurred here. She sold her home of 28 years to move her daughter to a different school. So I would just appeal to other victims that are out there, either of this or other circumstances. Find your voice, figure out what to do. You don't have to take it. If you're facing abuse, if you're facing crimes, you don't have to take it. I think law enforcement care. And I think in most instances, law enforcement cares. And I think most adults of goodwill care. And they want to hear from you. They want to know what's happened.
Subodh, thank you very, very much. It was wonderful seeing you again.
Good to see you, Bertram.
These are difficult circumstances, obviously, but I wish you all the best.
Thank you.
And we'll be in touch again.